Judge. Be seated, and thank everyone for being here today. Our business this morning, of course, first going to call a case of State of Mississippi versus Sheldon Timothy Herrington Jr., LK 25-147, and State of Mississippi versus Sheldon Timothy Herrington Jr., LK 25-522. Yesterday on a change of venue, we began to qualify the jury for a matter that we were going to pick a jury in Madison County. Once we got the jury picked, we were coming back to Oxford for start the trial of a capital murder charge. When I was qualifying the jury, I was notified that there had been an agreement reached by the parties that Mr. Herrington wished to change his plea from that of guilty not guilty to guilty. We went into a separate courtroom, and I took Mr. Herrington's plea of guilty at that time on both a charge in LK 25-147, wherein the charge of capital murder was reduced to that of second-degree murder, or what's commonly known or used to be known as depraved heart murder in the state of Mississippi. At that time, also a criminal information was prepared in LK 25-522, wherein Mr. Herrington entered a plea of guilty to tampering with the evidence. At that time, I pointed out to Mr. Herrington and his attorney, and they were aware of it, that this court had previously dismissed a charge of tampering with the evidence, in that this court feels that the statute of limitations had ran on that particular charge, and our court still feels that way. But the parties, in order to, as I understand it, in order to resolve this matter without the need of a trial, Mr. Herrington was going to enter the plea of guilty to that tampering with an evidence charge as well, and with the understanding that the court feels that the statute of limitations had ran on that. And I understand, Mr. Afram, that you advised your client that statute of limitations had ran, but in order to facilitate this, everybody was going to waive the issue of the running of the statute of limitations. Is that correct?
That's correct, Your Honor.
Okay. After taking the plea, at that time, as I understood it, the family of Mr. Lee, the victim in this matter, was not present in Madison County for the jury selection. They had intended to be here today when we began the actual trial of the case, and I was allowed the parties to reset the schedule, the sentencing in this matter for this morning, so that everybody who wanted to be present could be present, and we're here for that that sentencing today. I understand the parties had an agreement at that time and reduced it to writing in a plea petition as to what the sentencing would be in this case. Is that correct?
Yes.
All right.
Yes, sir.
All right. Is there anything else or any preliminary matters I need to deal with prior to announcing sentencing in this matter?
Your Honor, it's my understanding that Mr. Jr. Lee would like to address the court.
That'd be the father of Mr. The victim's father.
Yes,
I'll be glad to hear from Mr. Lee if he's welcome to come take the stand and make any statements he would like.
thank you, Your Honor.
proceed when you're ready.
I'm genuinely Jay's father. I'm broken father. I'm here to give a message and to just let Herrington know that I don't have a hell to keep you out of, or heaven. A hell to put you in, or a heaven to keep you out. I want to remind you of God's redemptive plan. As a minister, I have to give God's message to you. You don't have to go to hell behind this. You need to offer yourself to God to deliver you. I knew from the beginning that you did this. And I believe the family knew. I hadn't said much in this entire trial, but with my broken heart, I'm sharing God's love too. This is a sad day for our family, because we realize our son is not going to be here. We can't call him on the phone. He can't call us. I can't hear his voice. Only in my memory will I hear his voice. All the things that my wife and I gone through, his siblings, been heart-wrenching. But I know God is able. And I believe in the word. I understand that even in your arrogance, as you walked out the courtroom the last time, I did have to forgive you. But when they were killing Jesus, they were in full arrogance. As they began to let it be known that place the curse on us and not a generation to come, if we are doing wrong. So I want you to understand that God has a way that we can't go around. He has a redemptive plan that we must follow. So with my heart, I can't have my will and wish that my will be done, but I have to give us to the Father's will. I pray that healing takes place at this point. My wife and I, we've been living that July 8, 2022 day since that day. It took a lot. And no parent wants to face death of their child. But the pain of knowing that he lied there where he did all that time. When after he did a simple admission, then I had to witness my son's skeletal remains. I touched his skull. No father should have to go through that. No parent should have to go through that. Only thing I would say, Jay trusted you, but it did mistake to trust me in humanity. For we knew that humanity prevailed, people wouldn't do certain things, wouldn't go over a certain line. So I pray for this country's humanity to be restored. So people won't do the things that they're doing now, where countries are growing. And I think so many people that took place to bring this about. But I just wanted to address the court in Timothy and let them know what God has given me. And I miss my son every single day.
you would, Mr. Herrington. The court, having previously accepted Mr. Harrington's plea of guilty in these two cause numbers yesterday, and we're here for sentencing today, which I understand has been agreed to, and that there is a sentencing recommendation in this matter. Can the state advise me as what that sentencing recommendation is?
Yes, Your Honor. Yes, Your Honor. The state would recommend to the charge of second-degree murder that the defendant is sentenced to 40 years in the custody of the Mississippi Department of Corrections, with 10 of those years to be suspended and 30 of those years to serve, and 10 of those years on post-release supervision. To the charge of tampering with evidence, the state would recommend 10 years to serve in the Mississippi Department of Corrections. Both the first degree or the second degree charge and the tampering charge are to run consecutively for a total of 40 years in the custody of the Mississippi Department of Corrections to serve.
All right. I'm going to accept that recommendation of Mr. Sheldon Timothy Herrington Jr. and LK 25-147 on the charge of second-degree murder, or commonly known as depraved heart murder, being reduced from that of capital murder. The court is hereby sentence you to serve a term of 40 years in the custody of the Mississippi Department of Corrections. I'm going to suspend the imposition of 10 of those years, leaving you with 30 years to serve. Upon your release, you'll be placed on 10 years of post-release supervisions. The first 5 of those years will be supervised post-release supervision, followed by 10 years of 5 years of unsupervised post-release supervision. It'll be 5 years being the most years of supervised release that we can have in Mississippi. On the charge of tampering with evidence, the court is hereby sentence you to serve a term of 10 years in the custody of the Mississippi Department of Corrections. These two sentences to run consecutively to each other. It being the intention of the court that you that the court impose a total sentence of 40 years in the custody of the Mississippi Department, 50 years in the custody of the Mississippi Department of Corrections, with 10 of those years being suspended, leaving you 40 years to serve, followed by 5 years of supervised post-release and 5 years of unsupervised post-release. You'll pay all court cost fees and accept assessments in this case. You'll owe nothing on those court cost fees and assessments in this matter for a period of 1 year after your release. After 1 year after your following your release, you'll begin paying those court cost fees and assessments at a rate of $100 per month. The court's acutely aware that the nation has been watching this case from the get-go, the people in Mississippi. The state of Mississippi does not have a good reputation in matters concerning this, quite frankly. I may say more than I should say, but when I heard that we'd been getting national publicity over Mr. Lee's death and the fact that he lived a lifestyle that was different from most people in Mississippi, I assumed that a lot of people in this country thought that there will not be justice in this case. I want the world to know that Mississippi got it right this time. This case was investigated more thoroughly than any case I've ever dealt with in my 35 years in the criminal justice system as a prosecutor or a judge. It was defended by both these attorneys and Mr. Harrington's previous attorney, as well as any case I've dealt with in my 35 years. Everybody did their jobs. And ultimately, the state of Mississippi got it right. And I want to thank everybody for y'all's involvement in it. Mr. Herrington, you still have a chance at life. Mr. Lee did not, but you still have a chance at life. I'll encourage you to take advantage of that opportunity, okay? All right. The defendant will be in custody of the sheriff to transportation to the proper authorities, okay? All right,
Thank you.
and we'll be dismissed.
Thank you.
Court be in recess.